My lord, this is an IA for correction of typographical mistake in the cause title of writ petition, my lord. Make
No,
a-
it cannot be. You have to file amendment of it.
Yes, my lord, that has been filed. IA
Friday.
already filed, my lord.
What do you want?
IA is for for granting permission to, my lord, correct the cause title. my
You
lord.
want the IA to be listed
Yes.
on Friday?
Yes.
Yes.
But I beg to mention item number 9, my lord.
Yes.
My lord, I am for respondent number 7 and 8. I have some personal difficulty. Let it be on Tuesday, my lord. Next.
You have informed the
Yes,
other-
yes. I have
with
informed.
the consent of the learned counsel for the petitioner.
3rd December.
1 week I'll adjourn it. That's all. Mr. H. Das, learned counsel for respondent number 7 and 8, 6 adjournment in this case by citing personal difficulty. Since the prayer is not opposed, same stands allowed. Hearing of this matter stands adjourned for a week. List accordingly.
May I please, your lordship? First, I beg to mention for item number 13,
Hmm.
lordship, on the ground of personal difficulty, praying for seeking adjournment on the matter for today, lordship.
You are for petitioner.
And respondent number 1,
You have informed the others
petition.
with the consent of learned counsel for the opposite party. No, I'll not give any firm date.
Okay.
No, then you argue it today. This business will not work because there are other matters fixed on that day. You want a fixed date and then you will not do the matter when it comes and judges come reading the file.
I am not taking you.
Then we'll take it
Okay,
up, take
okay.
up the matter today. Yes, no adjournment. This
Adjournment-
business has to stop. One of you ask for adjournment and then you want a fixed date, then other matters fixed on that date that gets disturbed. That will not.
No
On
need
the
to fix
request
it,
of the learned
lordship.
counsel for the respondents made with the consent of the other side, hearing of this matter stands adjourned for a week. List accordingly.
Lordship.
May I please, your lordship? I beg to mention for listing 2 writ petition, your lordship.
For what?
For admission hearing, your lordship.
2nd week of December.
Maybe your
Yes,
lordship.
next
First
second
week, your
No,
lordship.
no, 2nd week of
Hey,
December.
your lordship, my senior Mr. Anthor, he's come from Delhi to hearing this matter, your lordship. First week,
Not possible.
your lordship, kindly.
Rejected. Your entire prayer is rejected. This prayer is not granted even for 2nd week.
Similar to writ petition regarding.
2nd week of December.
Yes, lordship.
Similar prayer, your lordship, for this.
2nd week of December.
Lordship, I beg to mention item number 11 of today's daily list on the ground of personal difficulty. The matter may be fixed on any date.
You are for whom?
I'm for the applicant, your lordship.
On the prayer of learned counsel for the petitioner, this hearing of this matter stands adjourned for 2 weeks.
Supplementary list for withdrawal item 15.
Mr. S. Kotakil, learned counsel for the petitioner, submits that he has instructions to withdraw this writ petition. The prayer for withdrawal is not opposed by the learned counsel for the opposite parties. In view of the above, this writ petition stands disposed of on withdrawal. Is there any stay order here?
No.
Yes.
Maybe lordship. I also want to do with the liberty.
Mr. R.P. Sharma, learned senior counsel appearing for the petitioner, submits that he has instructions to withdraw this writ petition with liberty to file afresh. The prayer for withdrawal has not been opposed by learned counsel appearing for the respondent numbers 1 to 6. In view of the above, this writ petition stands disposed of on withdrawal with liberty.
With liberty, my lord. With liberty.
Daily list for admission item 1.
My lord, first of all, I would like to take your lordships to the order dated 28/10/2024.
Yes.
My lord, your lordship will find we were asked to file one affidavit. My lord, what happened on that day, my lord, is, my lord, we relied on unamended regulation, where, my lord, regulation 4E was in major penalty. Now, after I took my lord, I had an interaction with the manager of the bank. Now, he said that was an unamended. Amended is 4E is a minor punishment. My lord, I will take your lordship, kindly see, this is the.
So additional affidavit was directed to be filed.
Well, it's not required because it comes within, the minor penalty comes within the 4E. So in the earlier unamended, it was shown in 4E as a major penalty. That was mistake on our part.
It is not required, but the direction of the court is
Yes,
required. to
yes,
be
my lord,
complied.
I am aware of that. My lord, if your lordship feel I can file an affidavit.
The court has directed it-
Yes, yes,
the affidavit to be filed.
my lord. So I
So-
thought because it was our mistake, because Mr. Chakravarti also relied on that unamended one.
Mr. Datta, I appreciate what you
Well-
are saying. It can't be that there is a direction to file, but I will not file. Then
No,
you
no.
ask for modification of this order.
Right, my lord, then I will file.
Either you apply for modification of this order or you file the affidavit.
I'll file that.
The court order has to be
Yes,
binding on this court also, no?
exactly, my lord.
I can't ignore this order.
Surely, sure. And the court order has to be respected, my lord, by any means.
Or you may have a good ground, then you file a application saying that please recall this order. It's not necessary. And if he agrees, the matter ends there.
And I'll explain the way why I'm by way of
It's
affidavit.
short,
Yes, yes.
1 or 2 pages.
Right.
Mr. Chakravarti.
Since there is an order, otherwise this this is an admitted position now in view of the amended provision, the penalty imposed is a minor penalty. So,
What is the penalty imposed?
my lord, reduction of pay by 3 stages. Here is a case where the petitioner was proceeded under the major penalty procedure and the punishment was imposed. And the petitioner in the earlier round of writ petition approached this honorable court and the inquiry was held to be bad. And the direction was given to go for a de novo inquiry, giving him every opportunity to represent, and then based on the finding of the inquiry officer, a penalty should be imposed. And while disposing the matter, this honorable court expressed or observed that a minor penalty may be given. Now, that was challenged in an appeal. Appeal was also dismissed. Now, what they have done, instead of going for the de novo inquiry, they have just issued a notice and imposed the penalty.
Okay, now I understand the technicalities. On an oral prayer also, this order can be modified.
Yes, I think,
both
my
of you
lord,
agree?
say it is admitted, my lord.
Is that
Then we'll recall this order and then fix it for admission here.
Right, my lord.
well,
Correct. Take down. Heard Mr. S. Chakravarti, learned counsel appearing for the writ petitioner. Also heard Mr. S. Datta, learned senior counsel assisted by Mr. S. Datta, learned counsel appearing for the respondents. Full stop. Mr. Datta submits that on 28/10/2024, a direction was issued by this court asking the respondents to file an additional affidavit on the assumption that the respondents had decided to, on the assumption that a major penalty, is it a major or minor
It's
penalty?
a minor. 4E is minor.
No, under the amended regulation,
it is minor.
4E is minor.
But under the unamended, it is major.
It was a
Major.
major.
Yes, additional affidavit clarifying as to whether also directing the respondents bank to file an additional affidavit so as to make it stand clear on the issue reflected in the order. First up, Mr. Datta submits that the order dated 28/10/2024 was passed by the court on the basis of submissions and projections made by the counsel for the parties based on the unamended provision of the relevant regulations. However, as per the amended provisions of the regulations, namely,
Regulation 4E.
Regulation 4E, the penalty imposed upon the writ petitioner is a minor penalty.
Minor.
Full stop. Since the regulations itself makes it clear that the penalty is a minor penalty, there would be no necessity for the respondents to file an additional affidavit in this case. As such, Mr. Datta makes an oral prayer to recall the order dated 28/10/2024 and post the writ petition for final hearing and disposal. Mr. S. Chakravarti, learned counsel for the writ petitioner, has agreed to the said proposition and has conveyed his no objection if the order dated 28/10/2024 is recalled on the oral prayer made by the respondents' counsel. In view of the above and having regard to the and having perused the provisions of Regulation 4 bracket E of the regulations of the bank, which provides that reduction to a lower stage in the time scale of pay for a period not extending 3 years without cumulative effect and not adversely affecting the officer's pension would come within the domain of minor penalties. I am convinced that the prayer made by the respondents' counsel deserves to be considered and allowed by this court. In view of the above, the direction to file additional affidavit issued by order dated 28/10/2000 so and so is hereby recalled. Consequently, there would be no necessity for the respondent bank to now file an additional affidavit registered to list this case for admission hearing again after 2 weeks. On that date, the matter will be taken up for final disposal.
Can I have a date, my lord?
After 2 weeks, date will not give, why? Because if I give a date, then I will not adjourn it. That undertaking has to come. Every time we are giving date, matters are being adjourned. So let the registry space it. After 2 weeks, fixed item means it will come either on the 14th day or 15th day or 16th day. What is the difficulty, Mr.? Why is the bar not making a request that all cases there should be fixed date? Why?
I'll request.
You
the
make a
president.
request to the
Because-
Honorable Chief Justice that every case there should be fixed date. Then there will be consequences which again you have to follow.
The only
Fixed date, I know everybody wants. People want clarity. But it creates problem for the bench.
my problem is the petitioner is a man of 85 years old.
This case again on 22nd of January 2025 as a fixed item. Yes.
Obliged.
Date will be January then because it can't be, fixed dates can't be given like that.
Lordship has fixed it on
22nd of January 2025.
Obliged.
May it please your lordship.
May it please your lordship. Lordship, we have filed our affidavit in reply against the affidavit in opposition filed by respondent number 3. We have filed it yesterday, lordship. The affidavit may be brought on record and the case may be listed on Thursday, lordship.
In my humble submission, the reply is not required because there's urgency also in the matter. What has happened is we wanted to initiate an inquiry.
This reply is not required.
The reply that has been filed by the petitioner against the affidavit filed by respondent number 4. In my humble submission, it may not be required.
What may not be required?
That reply to be brought on record. She is seeking time that the reply is not on record. So what my submission is, maybe that reply to be brought on record may not be essential or required in view of the facts that I may just present before lordships. Because there is urgency in this matter. What we wanted to do was initiate a departmental proceeding against them. That has been stayed. So all that we wanted is to give us that go ahead to go for that domestic inquiry or departmental proceeding. Only to that aspect. What has happened here? The petitioner who had applied for the post of driver had given his license by saying that the license is 4 years. The requirement is a 4 years valid license. Now they gave a license, then they said that the license is valid for 4 years. Later on, the DTO of the concerned transport office gave us the report that no, this license is not 4 years valid, it's 3 years valid. And our advertisement essential criteria was that they are supposed to give a 4 years valid license. Unless and until that's the eligibility, they cannot participate. Now, the particular petitioner had participated, selected, and was working.
All right. So are you ready to argue the matter today?
So we just wanted to do that
Thursday,
inquiry.
lordship.
Huh?
On Thursday.
Why not today?
Lordship, the affidavit is also required,
See, it is,
lordship.
that's what I told Mr. Chakravarti just now. You must understand the bench also has its priority and
Yes, lordship.
trials and tribulations.
Correct. Lordship.
You casually ask for fixing date, post it on that
I
date,
understand.
day. The bench, the judges have to also come with some preparation.
It's true.
Half the matters, 75% of the matters which are fixed are never taken up. One of the sides is not ready or is asking for adjournment, and then the whole thing gets.
Correct, lordship.
So if you want fixed dates, then you have to stick to it.
Yes.
You will not take responsibility for that side will not take responsibility for this side. We have tried to give this to the bar,
Correct, lordship.
but it's just not working. Mr. Chakravarti, you want a preponement of your date, 7th of January?
I'll be
All right.
obliged with your lordship.
Please tell Mr. Datta. No, if the bar wants fixed date for every case, then you have to come with some responsibility also.
Well,
It can't be that give a date and it is up to me, I may or may not do the case.
No.
That can't happen.
of course.
Because lawsuits will
Because
also
if you
take the
fix the
trouble.
date, the cause list is prepared now. By fixing dates, I am preparing the cause list, not the registry. And
Yes.
then in my cause list, I don't know which matter will be taken up. Because on flimsy ground, my senior is this, my so-and-so is gone there. Somebody is wedding, the matters are being adjourned. If we don't allow it, then there will be resentment in the bar. You come up and say, no, that every matter we want fixed date with an assurance that any case date is fixed, except for medical emergency, we will not ask for adjournment. We'll give you. Is the bar ready to do that? Because when we fix a case, we come reading the file.
Yes, lawsuit puts an
Our time
effort in that
cannot
case.
be wasted like this. Sorry. At least this court will not. We put in a lot of effort to come to the court ready. And the counsels are casually asking for time. Is that? Look at the ground. She is not ready to argue.
Lordship, the affidavit is required, Lordship.
It's not required.
The
Argu?
DTO has from his record stated that it is 3 years old license. Now a reply, what they are going to better that? How they are going to better that in a reply? The DTO's affidavit is on record. It says the license is 3 years.
On the request of Ms. P. Sharma, Mr. Chakravarti, 7th January.
Ma'am.
Please inform Mr.
My lord, I'll inform.
I have to go to 7th January. I have to list in the next week as a fixed item by tagging the affidavit in reply filed by the petitioner. It is made clear that on the next date, no adjournment will be granted to either side.
Because the person who is ineligible is now working. That is our
1 week
predicament
you can wait. Mr.
Yes.
A. Sharma, learned counsel is appeared for,
for all India limit. Respondent number?
and Ms. M.D.
That's
Bora
it.
for respondent number
Respondent number 4, 5, Lordship.
4 and 5 and 3. Who's for 1 and 2?
4, 5, 6. 8, Lordship. Transport Department. Passport.
1 and 3.
1 and 3. You don't even know who you are appearing for. It takes 15 minutes to say that. Look at the state of affairs. 90% of the counsels don't know who they are appearing for.
That's right, my lord.
Go to the record. Am I appearing for the? We want to save time, judicial time, and that's just not happening. Is it not incumbent on you to come and see which respondent you are representing before standing up before the court? Every time I dictate an order, then people start looking which respondent I am appearing. Standing counsel is fine, but you are appearing for some respondents. So people only say I'm standing counsel so and so, standing counsel. How does it type out the order? I've been requesting the bar to point out. It's not happening. It's too much to open the brief and find out who you are representing. See, if you want faster delivery, then rights is correspondent with some duties. You have to discharge your duty. Faster delivery, 50 cases a day disposal, I am ready. Give an assurance that fixed matters, no adjournment. You will come prepared with the facts. This court is ready for hearing at least 50 cases a day. But it doesn't happen. I've tried out. It doesn't happen. For some reason or other, 50% matters are adjourned, another 25%. But that happens, I do understand. The system has its own difficulties. But if there has to be a change, then it has to be overall change in the system. So I'm requesting you to be please prepared with all these things. Yes, next matter.
Obliging.
May I plead your lordship? Your lordship, kindly peruse the last order dated 12/11/2024 and 19/11/2024.
May I plead your lordship? Lordship sometimes may be given lordship kindly. 10 days that may be given lordship.
My lord.
Lordship instruction is awaited your
12/11/2024,
lordship.
my lord, they have not even filed affidavit after.
Correct. Argue for disposal.
My lordship. My lordship. The impugn order is on page 33, my lordship.
Yes.
Page 33, my lordship. There, whereas a reply to show cause notice is submitted on 19/5/2000.
What show cause notice? Who are you? Contractor?
No, my lord.
Then start from there.
Yes. My lord. I am accredited engineer, my lordship.
When were you appointed?
My lordship, I was appointed in the year in the year 2010, my lordship, 13/12/2012 issued the order, page 22, my lordship,
Page?
22. Joining report is on page 23, my lordship. And terms of contractual engagement is on page 25. I was suspended earlier, my lordship, and I came before the Honorable High Court with a writ petition, which I have annexed, my lordship.
So appointed as accredited engineer.
Yes, my lordship. And I came with a writ petition. And
Then what happened? After that?
after that, my lordship, I was suspended illegally. Then I came before the Honorable High Court. I annexed the order of the Honorable High Court, page 16, Annexure 1, my lordship. The operative portion is on page 19, my lordship. May I read, my lordship? Resultantly, the impugned order having been held to be stigmatic, a court has no hesitation in setting aside and questioning the order under memo number such and such. Resultantly, the petitioner is found entitled to be reinstated in service. Accordingly, respond number 1, that is the Commissioner, Panchayat and Rural Development Department, is directed to pass consequential orders within a period of 4 weeks from the date of receipt of certified copy of that to reinstate the petitioner in service, but the entire period of absence shall be treated as dies non. The petitioner will not be entitled to any salary wages for the period he has served, and that he also not be counted towards the period of service for purpose of retirement benefits, my lordship. Then, my lordship, order dated 1st February 2021, page 20, Annexure 2, my lordship. Annexure 2, page 20. In compliance of the Honorable High Court's order,
Yes.
I have been reinstated, my lordship. And my post is accredited engineer is reinstated to the post of AE and posted.
When is the order of reinstatement?
My lordship, page 20, Annexure 2. That is the date is 1st February 2021, my lordship. My lordship. Thereafter, my lordship, the Annexure 6 may be to page 27, my lordship. Annexure 6. There was a departmental proceeding against the accountant of my development block, my lordship. I was asked to appear as a witness, my lordship. My name is Surajit Roy, real number 1, my lordship. Page 27, my lordship.
Which document you are referring to?
Annexure 6, page 27. There are 1, 2, 3, 4 employees. They were asked to appear to give witness, my lordship, in a departmental proceeding against accountant category development block. There was an allegation of misappropriation of government fund, my lordship. So I was asked to appear as witness, my lordship. Then, my lordship, thereafter, Annexure 8, page 30 may be seen, my lordship. I have been given show cause notice, Annexure 8, page 30.
Where is your show cause notice?
Annexure 8, page 30. After my appearance as a witness
Hmm.
against the departmental proceeding against that accountant, my lordship, I was given the show cause notice. There is no specific allegation in the show cause notice, my lordship. But in spite of that, I have submitted my reply. My reply on page annexure 9, page 31.
Just a minute, what is the show cause about?
Yes, my lordship. In pursuant of the gov letter such and such, an inquiry submitted by Deputy Commissioner by letter number such and such, it has come to notice of the understanding that you have been engaged to implement the various works under MG and Rega program as Rajatila Gau Panchayat. But as per inquiry report, without implementing the works properly, you have been found involved in gross irregularities and misappropriation of government fund. No specific allegation, my lordship, that I have been involved in misappropriated government fund, my lordship. And therefore, you are charged with gross negligence of duty and misappropriation on government money with malified intention, my lord. No specific allegation has been raised, my lord. And in the inquiry also, my lordship, I was not a part of that inquiry, my lordship. And I submitted my reply on then my show cause notice, my lordship. Reply is on page 31, annexure 9, my lord. Paragraph 3 maybe is irrelevant, my lord. I joined on 1/2/2021. Just, my lordship, 1 month before I was heckled in the office. Immediately after joining the office, my lordship, that incident happened. And I reported before the block development officer. On 1/2/2021, I joined, my lordship, after my reinstatement, and I submitted letter, my complaint on 1/3/2021. In between that, only 1 month, my lordship, after my immediate joining, my lordship, and I complained before the BDO. And that is prior to release of the fund, my lordship. And my impugn order, my lordship, is on page 33, my lordship. There is no reason has been stated, my lordship, why my show cause reply is not satisfactory, my lordship. Only it is stated that it is not satisfactory, my lordship. No, it is not reasonable order, my lord.
Where is the contract agreement page?
My lordship, it is on page 24, my lord.
The contract is valid till when?
My lordship. It was the terms of contract, my lordship, it has been already over. It is no dispute, but I was reinstated as per the order of the Honorable High Court, my lordship, and that is my lordship, page 20, my lordship, and except 2 I have annexed, my lordship. I was doing service for more than 10 years, my lordship. Continuous service,
So even if this order is set aside, your contract, if it is over,
my lordship.
then how can you continue in service?
My lordship, my contention is that, my lordship, I have submitted my reply, my lordship.
We'll set aside it, but
Yes.
say that if the contract is over, you will not be reinstated. What
My lord,
benefit will
for
you
more
get?
than 10 years, I am working, my lordship.
So what?
Continuously, I am working for.
Therefore, you should be allowed to work for another 10 years.
My lordship.
That is the law. Show me the law on that. How much time you want to show me the law?
My lordship, my contention is this in this petition is that, my lordship.
Do you have
the
an answer to the court's query or
order,
not?
my
Tell me.
lordship, it is unreasonable. Impugn order is not reasonable, my lordship.
Correct. Then, but your contract is over. Your service contract, the tenure of the contract.
The respondent may be directed to take a decision, my lordship, on that, my lordship, because they have reinstated me, my lordship. I am working for
That is
10
over.
years.
That is the last round where the order was found to be stigmatic.
Yes, my lordship.
But now, first of all, your contract period is over. Secondly, you have admitted that under pressure, you have replaced the bill and made it 29 lakhs something.
Yes, my lord.
Who has exerted pressure on you?
My lordship, when I joined
Who has exerted pressure on you?
in the complaint, I have stated everything before the book development officer, before the passing of the bill. It is on record, my lordship. Because just I joined the office, my lordship. Immediately after joining the office, I was heckled, my lordship. And the block development officer himself orally instructed me that do it, my lordship.
Where is that statement?
My lordship. I have in the statement, my lordship.
In the writ petition, where is the statement?
Yes.
Mr. Laskar, you have to do some hard work here. This much of effort will not get you relief here.
My lordship, I have stated, my lordship. Page 28, my lordship, to the additional deputy commissioner, annexure 7, paragraph 3, I have specifically stated in the inquiry report, my lord, while that inquiry was done, my lordship. Annexure 7.
What to do? You have done some mischief. They have given you a notice. You have given your explanation where you have admitted that you have done it. So they have terminated your service. The contract period is over. How can you be reinstated now?
My lordship, I have not done anything, my lordship. That opportunity they should give
All right,
me, my
Mr.
lordship.
Asbil Asgalari, counsel for the petitioner on the request of learned departmental counsel appearing for the respondents. This matter is directed to be listed again after 2 weeks so as to give her one final opportunity to obtain instruction as called for by this. You come prepared. This much will not help. Your contractual period is over. You cannot get a reinstatement. That's the law. Or else come with a decision which helps you.
Lordship 4 and 5, Lordship, here by additional senior, AG D. Mojumdar, he is appearing. So he is on legs, Lordship, kindly timing. Pass over for the timing.
What is this matter about?
Yeah. This is with regards to a person who was working as a deputy commissioner in Sirang. There is some footage come in some news channel, wherein on the basis of which FIR has been registered and he has been arrested, put behind a bar. Subsequently, search sheet was submitted, cognizance was taken, and on the point of charge, the learned special judge, Assam, heard the matter. And the main ingredients with regard to the main allegation is regard to the footage. The footage was part of the evidence on record and it was subject to FSL also. It was genuine. Now, on that very basis, the person has been discharged. On the same facts, my lord, department proceeding were initiated. So cause notice has been given to me. Some documents has been relied on, my lord. And these documents, my lord, includes that electronic records. I was asking for electronic records. I was asking for statement of the witnesses recorded during inquiry. Nothing been furnished. Even then, without prejudice, I have filed the reply. Now, inquiry officer was appointed, my lord. Inquiry officers finds, my lord, no fault on me. So it has been sent to the authorities concerned. Also, authorities in the 2019, my lord, passed a disagreement order, my lord, disagreeing with this. Challenging the whole of the departmental proceeding, this case has been initiated, my lord. If your lordship see the last order.
What is the penalty imposed?
Nothing, my lord. Disagreement 2019 and slipping over the matter. In 2023, my lord, we challenged this whole of the departmental proceeding, my lord. And this honorable court came to a finding that the charge on which the criminal case was laid and the departmental proceeding was on the same facts. And as such, as because I have been discharged in the criminal case, so this departmental proceeding on the same charge will not there.
No, that's not correct. That's not the law.
That's been the, my lord, been finding, and that's been a law which I have brought it with me, my lord.
No, that's not the law.
But the very basis with regard to this, my lord, a person who has been charged on the basis of some footage been shown in some TV channel, he's been subject to FSL, not been furnished to me, no document has been furnished.
That's
to me.
another matter.
Yes.
But to say that if he is acquitted in the criminal case,
Yes.
the departmental proceeding will automatically go, that's not correct.
No, my lord, that's not the thing, my lord. What the Supreme Court said, my lord, if the facts are identical, the issues are identical.
Simultaneous proceeding will not be done.
Yes, that's a different issue. But when, with regard to departmental proceeding, what was the allegations in the show cause notice, statement of allegations, and with regard to in the criminal case, if it is same, then the court judgment to the full idea. I'm putting it before this honorable court. Photocopy to the.
Yes, what is the stage of the departmental
Lordship,
proceeding?
that
What is
I'm
it?
not aware of because I'm not assisting.
No,
Lordship. He is-
find out.
He is on Lake's Lordship. He will be coming.
All right, when he comes, then you come with
Lordship.
the instruction. What is the exact stage?
Departmental proceeding has been stayed by this court, my lord.
Has been
After
stayed.
2019, they have disagreement, my lord, and sitting over the matter, nothing been done. In 2023, my lord, I challenged it, my lord, and this has been stayed before by this honorable court. And the person has retired in 2018 itself, my lord, and he is getting a provisional pension for which I filed the other writ petition, my lord. After the court's order, provisional pension has been paid, and still now he is struggling, my lord. He is in bed, my lord, suffering from blockage and all. Still now it's going on, my lord. And the judgment I am relying on this 99 judgment, my lord, 3 SSC, my lord, paragraph 34 and 35.
What is the party citation?
Yes. Captain M. Paul Anthony versus Bharat Gold Mines Limited and another, my lord.
Yes, this law is still good, but there are subsequent judgments also.
Yes.
Lordship.
Uh,
One is SBI versus P. Jadinda, Lordship. Does help that it can be.
It can be, my lord. But wherein, my lord, if I point out to this honorable court in the representation of a representative, give me the footage on the basis of which you are making the allegation. That doesn't furnish it. Whole of the inquiry without the footage itself. my
So
lord.
will you be happy if an order is passed to give the footage or not to rely upon it and conclude the inquiry within 6 months?
My lord, I am on the quashing of the whole case, my lord. Why? Because TCL, that larger bench judgment, that's been a good law as on today. Whole de novo trial again, my lord, for me, a person who has retired from service in 2008 after 6 years. And that too, the footage itself, my lord, on the basis of which they have given me the show cause notice, is been subject to scrutiny by a competent court of law having jurisdiction.
No, Mr. Anand, let me make it very clear.
Yes.
That argument is rejected. Because in criminal trial, the standard of proof is different. In a departmental proceeding, the standard of proof is different.
My lord.
So on the same charge, if a person is acquitted in the criminal case,
My lord.
that does not lead to a discharge in the exoneration in the departmental proceeding. That law is very firmly established. So there is no scope for this court to hold to the contrary.
Hmm.
All I'm saying is,
Yes.
unless you can show a latest judgment which overrules the earlier judgments, you will be wasting your energy arguing that. But if you are arguing on a prejudice on the departmental inquiry itself,
Itself, my
for
lord.
example, they are relying on materials which they are not
Not been
supplying
supplied
to
to
you.
me, yes.
These are established principles, your rights are to be protected.
Yes, and
There's
that's
no
been the
difficulty.
violation of Rule 9 itself, my lord, the
That-
1964 itself.
that
my
the
lord.
court agrees
That
with you.
whole departmental proceeding goes.
But then department proceeding does not go.
But as for TJL, my lord, it will be according to that, my lord, it will be from the stage wherein, my lord, it is to be
No,
furnished, and
no.
whole of the proceeding has to start again.
No. No,
Because
if-
these documents are part of the so-called notice.
If they have not supplied copies to you, they cannot rely upon this document. That's the law.
And if this doesn't rely on this document, whole case goes, my lord.
That inquiry officer has to give the findings.
Inquiry officer's report is in my favor, saying no, nothing has been made out. And when there is a disagreement, my lord, there has to be reasons on record. The reasons are in my favor.
Okay, so the disciplinary authority disagreed with the inquiry officer.
Yes.
But was a notice given to you before,
After disagreement, notice has been given.
but not before?
Not before.
So give the judgment, we'll quash it.
My lord,
The matter has
I'm
to go.
putting it now. No, he doesn't. No.
There has to be a notice
Yes.
before disagreement.
Yes.
Where is that judgment?
That judgment I have not brought in, my lord. With regard to disagreement judgment, my lord, it has to be reasons on record.
That's right.
Yeah, and from the record itself, I can show that after disagreement, notice has been issued.
Mr. Bhuya, you have a better case if the disagreement has been recorded without giving you an opportunity to show cause.
My
The
lord.
whole thing collapses on that.
Yes, my lord.
Where is the judgment?
Next date, my lord, I'll bring it on record, my lord.
You are not harping on. a
I'm
point.
sorry, my lord. I'm sorry, my lord.
Here and there.
I have limited knowledge with regard to service matter. It's every day I'm learning from your lordship and
That's
from
the
my
clincher
colleagues.
for you.
Yes,
Clincher
yes.
for you.
Yes.
The whole exercise of disagreement will be vitiated and
Vitiated,
therefore
my lord.
subsequent actions will fall apart.
Absolutely.
As simple as that. You're
Absolutely.
going on criminal case, discharge and that's too well settled.
Even
law.
I'll try to, my lord, locate, do the recharge part that whether now 99 judgment has been with me, I am relying on. Subsequent judgment she is talking about and latest judgment with regard to this. Because, my lord, one thing is very sure. Whole of the department were on a footage, TV footage, CPE footage. My lord, can you see the minimum thing? Footage is been subject to FSL verification and been submitted in a court of law. Court of law. Oh, I say. Yes. Yeah. So that particular footage, the court of law has scrutinized, seen it, this one, heard me at length, heard the prosecution, and thereafter discharged me. They have no appeal been lying. So basic itself is
Will have
gone.
nothing to do with the departmental proceeding.
My lord, yes, it will be. Yes, this is the judgment, my lord. Para 4 DDA. DDA. Yes, there is a judgment, my lord. I'm sorry, my lord. I have bought it, my lord. It's been reflected. This is, my lord, State Bank of India and Nani Gopal Palit. Judgment they are referring to, my lord. That I have bought it, my lord. Paragraph 4, my lord. Opportunity of being heard. What is called out from the views expressed by the Supreme Court in the aforesaid two decision is that when an inquiry report is in favor of the delinquent officer and the disciplinary authority propose to differ with such conclusion, it is imperative that the delinquent officer must be given an opportunity of hearing. Mere issuance to the show cause notice would not serve the purpose, inasmuch in a departmental proceeding, what is of ultimate importance is the finding of the disciplinary authority, and such finding cannot be concluded by wishing away the principle of natural justice. That is the paragraph.
Yeah, this judgment is on the point, but there are better judgments.
Yes, I'll do the recharge part.
Would you like to find it out today, or you want the matter to be taken up on another day?
Any other day, my lord. I'll do the
Any other
recharge
day.
part, my lord. Whatever query has been made, I'll come with the latest judgment, my lord.
Yes. See, Ms. Bhattacharya, you must also brief because we need to cut down on our unnecessary exercise.
Understood,
Yes.
Lordship. I shall.
If no show cause notice has been issued before disagreeing with the report of the inquiry officer, the whole thing will be quashed.
Lordship.
That's the law, and We'll hear the arguments, but needless arguments will not be of any. That's the law. This judgment is there. There are other 2, 3 very good judgments of Supreme Court on this point.
Give him an opportunity, otherwise he'll be condemned.
So if that is not the case, we think whole thing falls apart. And therefore you have to process this pension, as simple as that.
Lordship.
But if the officer was given opportunity to show cause, his reply was taken note of, then you have to show the records, which you don't have.
Lordship.
So in any case, what is left in this case?
Answered, Lordship.
Mr. Borua, why are you so, why are you so,
Next case because.
next case?
No, I remember five.
Ah,
Part. It was regarding payment of. Pension and not come. We have paid. It is not my submission.
no, but it'll all depend on the outcome of the item.
Yes.
Because.
Hmm.
This amount we paid already. Leave encashment also.
And what really is the allegation against the petitioner?
Lordship, as I am not aware, I'm.
I have
assisting
taken
him,
bribe
Lordship.
of 30,000, my lord.
Hmm.
That is the allegation. The footage, on the basis of footage, this allegation has been made. There was no affair, nothing, my lord. And the footage, when been seen by a court of law, my lord,
Hmm.
it's been saying that money has been put in my table. I said, refused. And the learned court, my lord, has come to a finding that he has not demanded, he has not received, rather he has refused it. That's the finding of a court of law, my lord. And my lord has been talking about that particular judgment. Yes, it is with me, my lord. Paragraph 19, my lord. 7(2) violations, my lord. We'll kindly come to the writ petition, page 71. 29/11/2019 is
So
the
all right,
order of this agreement.
both sides you come prepared on this. We'll-
I'm prepared, my lord, with regard to this, my lord. The judgment has been there, my lord, and the authority is there.
Lordship and time being, Lordship.
98, my lord. Yes. Acha kuri diyo, no? Huh?
Timely.
Notun kiba aise, take a short time, my lord, if your lordship can
See,
accommodate.
Mr. Bhuya, I'm
Understood,
telling you,
understood, my
decide.
lord. I will
You
not
want to
debate
do
for
it
this.
today, you do it today, you want to do it some other day. But once I take up the matter, I will not adjourn it.
Ah.
So it is up to you.
Short time,
if
my
you're
lord.
comfortable today, do it. Any other day you.
Any
take-
other day, my lord,
you
any
take
other
when
day.
you
I'll
want.
do the recharge part, my lord, because
When
lordship
do you
is
want
saying that there are latest judgment on this point.
When do you
Let-
want it? When do you want it?
Any day, lordship's convenience.
Any day. This matter any day.
My lord. In December, my lord, if it's possible.
That means which day of December?
5th, 6th of December.
On the request of Mr. Bhuya, learned counsel for the lead petitioner, this matter is directed to be listed again on 5th of December
5th.
as a fixed item.
Deeply obliged for it.
Your Lordship.
But your case is on a very narrow campus.
Yes.
And if you can hit the nail on the head,
Yeah.
that's all. There's no point going here and there, what
Yes.
happened in criminal case. Whatever might have happened has got nothing to do with your case.
This agreement with 2019, then opportunity with regard to this moment 2020.
Matter ends there. Yes.
For hearing, item 6.
Made your lordship. My lord, claim made here is, my lord, notional promotion for the purpose of, my lord, pensionary benefits. Now, my lord, before I take your lordship to the, my lord, facts of the case, your lordship may kindly peruse the order dated 9/10/2023. What happened, my lord? There was a selection, and the selection, the petitioner's name was recommended, and it is the stand in the affidavit that the proposal has been rejected by the higher authorities. And by this order, it was directed, my lord, the respondents are accordingly directed to produce the order of communication of the commissioner, North Assam Division, rejecting the proposal of the deputy commissioner in respect of the selection made to the petitioners. That whether, my lord, that is the.
Oh, as part is order, I have seen also that the two things were being required. One is whether that thing was from promotion or not. And second thing is that order, lordship. First thing is that the promotion, lordship, that instruction I have, lordship. that I would like to inform that an advertisement was published by office number 72 dated for promotion to the post of Sadar Health Assistant. One thing is clear, and second thing, the rejection order that is not ultimately also, although we have sent our letter to the party, that the order of rejection is not before us, Lordship. So. it will carry on.
So will it be necessary, the order of rejection?
My lord, without that also, your lordship may decide the matter, my lord. Without that also, because the court wanted to see, because my case is that, my lord, my selection was in terms of the rules, and it is a promotion, and I was selected.
But there is an order of the court.
Yes, my lord. Let him produce it then.
Otherwise, the affidavit says that as it is not the minutes as it is not as per the rules, it was not been attacked.
I'll satisfy your lordship that this is as per rules.
What to do? Can this bench ignore an order of an earlier
Yes, that's
court?
fine. That's why, my lord, I had pointed out this order.
No, you have rightly done so. What to do, Mr. Chaudhary?
Let him produce it. my
Guide
lord.
the court what to do.
I think, my lord, if the produces this, that will be better because, my lord, I said this is as per the rules. They could not have been rejected by the higher authorities. Therefore, my lord, if they produce that it has been rejected, then I can also, my lord, point out to your lordship why that order is also bad.
That will give you an additional handle.
Yes.
How much time will you take?
2 weeks.
You take down. Heard Mr. M.K. Chaudhary, learned senior counsel, assisted by Mr. Kashyap, learned counsel appearing for the writ petition. Also heard Mr. C.K. Borua, learned government advocate Assam, appearing for the respondents. This matter was posted today for hearing as a fixed parted item. Stop. However, at the commencement of hearing of the case, Mr. Chaudhary, learned senior counsel, has invited the attention of this court to the order dated 9/10/2023, whereby a direction was issued to the learned counsel for the respondents to produce the order of the commissioner from a North Assam division rejecting the proposal in favor of rejecting the proposal drawn in favor of the writ petitioner, indicating his selection. Full stop. Selection to submit that since there is an order of this court, the respondents are duty bound to produce the said letter. Full stop. Mr. C.K.S. Borua, learned G. Assam, on the other hand, submits that despite communication issued to the departmental authorities, the letter is yet to be received by him. In view of the above, the learned government advocate Assam prays for 2 weeks further time to obtain the letter. Full stop. Considering the fact that there is already an order of the court calling for the letter and having regard to the hearing, the letter is likely to have in the outcome of this writ petition. The request made by the learned government advocate Assam is hereby granted. 2 weeks' time with effect from today is granted to Mr. C.K.S. Borua to obtain the letter, failing which adverse conclusions will be drawn in this case. Let this writ petition be listed again after 3 weeks for hearing.
Mine.
First.
I think 7.
May it please the lordship. The petitioners before lordship are regularized master of workers, my lord. Their services were regularized along with the others, my lord, batch in 2005. My lord, by order dated 21/10/2005, their services were regularized, but their salaries were not paid. As their salaries were not paid, they approached this honorable court by filing a writ petition. That writ petition lordship will file order lordship will find at page 59. Page 59, my lord.
Yeah.
May I read, my lord?
Yes.
Second para onwards, my lord. The 5 petitioners who were engaged as master worker in the Inland Water Transport Department prior to 1/4/1993 were approved for regularization by the government by orders dated 7/10/2005 and 21/10/2005. Thereafter, orders for regularization were issued by the government in the names of the petitioners. However, as salaries of the petitioners have not been paid, as regular employees of the department in the scale of pay applicable, this writ petition has been filed seeking appropriate relief. Having regard to the grievance expressed and the facts of the case, the court had thought it necessary to require the personal appearance of the Director Inland Water Transport in the court to explain the reasons for non-payment of salary. Sri Ansi Das, Director Inland Water Transport, who is personally present, has submitted that 1463 number of master workers engaged prior to 1/4/1993 were recommended by the Department for Regularization pursuant whereto the government orders dated 7/10/2005 and 21/10/2005 were issued, approving the names in question for regularization. However, in the recommendation made by the department and consequential approval orders of the government, the names of the petitioners were wrongly spelled out in the specific orders of regularization issued pursuant to the government approval. However, the names of the petitioners were correctly mentioned. As there was discrepancy of names in regulation orders of the petitioner issued by the department and the approval orders of the government, the Treasury officer has taken an objection, as a result of which the salaries of the petitioners could not be paid. The director personally present has further submitted that subsequently a corrigendum has been issued spelling out the names of the petitioners correctly, along with some other employees whose number is 57. The director has further submitted that the matter is now pending in the finance department, and once the approval of the said department is granted in the correct names of the petitioners, the impediments in payment of salary to the petitioners will cease to exist. The facts of the case as stated above makes it amply clear that the cases of the petitioners were duly approved by the government for regularization, though a mistake has crept in their names, which anomaly is now being corrected, and the matter is engaging the attention of the finance department. The fact of the case also point out that the mistake that has occurred is a clerical mistake, and that had occurred inadvertently. In such circumstances, the court is of the view the finance department should be directed to accord its approval to revise the names of the petitioners as submitted to the finance department by the Inland Water Transport Department. This should be done as expeditiously as possible, and in any case, within a period of 1 month from today. It is also made clear that as the approval of the regularization of the petitioners was accorded prior to the full bench judgment of this court, passed in WPC number so-and-so, reported in so-and-so, the directions contained in the said judgment shall not act as a constraint on the finance department to act in accordance with the present direction. Once appropriate orders are passed and the approval of the finance department is accorded, in terms of the present orders, salaries of the petitioners shall be released, including the arrear amount, without any delay. This was the direction of this honorable court, my lord, in the earlier round of litigation. What happened, my lord? Thereafter, the finance department.
Just 1 minute, just 1 minute. How many petitioners were there?
5 petitioners.
And here in this case, how many?
Here also, all the same.
Is the
petitioners.
same 5?
Same 5, my lord.
All right. Now what has happened?
My lord, after this order was passed by this honorable court, the finance department, my lord, preferred a review petition before this honorable court. And that review petition was tagged with another batch of cases. Those batch of cases were disposed of by this honorable court, directing the authorities to regularize the services of those petitioners. And the review petition was also disposed without, my lord, making any comment on the merit of the review petition. Thereafter, my lord, that order was challenged before the honorable division bench. Honorable division bench, that is the case of Upendas, my lord. And Upendas came out. My lord, what happened, my lord? Those in the case of Upendas, those petitioners were not regularized master workers. They were not regularized, and that is why they prayed before this honorable court for a direction to regularize their services. The learned single judge, my lord, directed the authority to regularize their services. My lord, consequently, my lord, open desk came, and in the open desk, my lord, this honorable division bench of this honorable court has, my lord, directed the authority to give some benefits without making their services regularized. But in my case, my lord, that judgment will not come, as my services has been regularized, and there is a clear direction of this honorable court to pay the salary after getting the mistakes rectified.
So what has happened? You have not got salary till
Not,
today.
I am still getting the salaries of master worker, my lord. Still getting the salaries of master worker, my lord. That is why this writ petition has been filed. And my lord, in this writ petition, my lord, though my lord, this writ petition was filed by another set of counsel, my lord, I will engage later on, my lord. I am not pressing the prayer one at page 32, my lord.
Hmm.
Page 32. Prayer A, my lord.
Yes.
Prayer A, I am not pressing, my lord. I am not required to press this prayer because my service has already been regularized. So, my lord, I am not required to be regularized again.
Yes.
My lord, in the review petition,
Hmm.
perhaps, my lord, that is also tagged with this petition, my lord.
Wait, let us see. The review petition is there. The review petition. What happened to the review petition? Was it disposed of?
It was shown to be disposed of along with that order, my lord, 2012 order, my lord. This is the order of 2012, my lord, judgment. In that case, my lord, it was shown to be disposed of. Yes, sir.
All right.
If you lordship use the order, I flag marked the review petition portion, my lord.
All right. So review petition was shown to have been disposed of, although there was no order on the merit.
On
of the
merit,
review
my lord. If a lordship comes to page 58, my lord,
Hmm.
there are 5 respondents in the writ petition. There are 5 respondents. Only one respondent, my lord, preferred the review petition. The other 4 respondents, my lord, they have accepted the judgment. They have not come for review. So, my lord, on that ground itself, my lord, the review petition is not maintainable.
So only finance department had preferred. that.
Only finance department.
And what
and the
was the
statement
ground?
was
What
made-
was the ground on which review was preferred?
Round of review was that, my lord, they said that in the proposal sent by the transport department, names of the petitioners were not there, and that is why their names were not approved. That is the ground they took in the review petition. My lord,
Proposal means proposal sent to?
sent to the finance department for regular approval,
Hmm.
for approval.
But you deny that.
We deny that, my lord.
Where is that proposal?
That proposal is not with us, my lord. Proposal perhaps, my lord, finance department will.
Where is the proposal, Mr. Nayak?
As per my
Lordship, in
instruction.
fact, overall,
Ah,
Lordship,
yes.
around 30,000 persons were regularized, Lordship, masteral as well as workers, Lordship. And that list was approved by the cabinet. On being approved by the cabinet, the government of Assam in the respective departments issued one approved list, Lordship. In the said list, Lordship, name of the petitioners were not there.
Hmm.
The director concerned, Lordship, of his own, without taking approval either from the finance department or from the government, included the name of the 5 petitioners and regularized their service. On being found out, Lordship, the concerned treasury officer stopped their salary. And that is how, Lordship, the earlier writ petition was filed. And Lordship may kindly see why we are aggrieved, Lordship, because of that judgment, Lordship. On 2-3 occasions, a line was there. The name of the petitioners were approved by the final government. That approval was not in fact there. That is the main reason of our filing the review petition. And so far as this petition is concerned, Lordship may kindly
You
see.
mean this judgment at page 59?
Yes, Lordship.
So what is the basis of this finding that the government had approved the petitioner's regularization?
But the statement was made by the director himself, my lord, before this honorable court, my lord.
No, that's right, but oral statement of the director, if it is disputed, that will not stand.
Yes, ma'am. But in that case, my lord, the director should have come before this honorable court for review. He has not come.
The
Yes,
direction was
absolutely.
to the finance department for granting approval. Ultimately, Lordship will see the last 2 paragraphs. Once appropriate order are passed and the approval of the finance department is accorded. So ultimately, judgment also said that approval was not there.
So why is the finance department not carrying out this judgment 1911-2007,
That is why we filed a review petition, Lordship.
saying that their names are not in the
Not
list?
approved by the cabinet, Lordship. And that was our.
And why their names are not approved? They were, if they were engaged as masteral.
Yes, they were also appointed prior to March 1993.
Correct. So
But
then they were also.
At that point of time, Lordship, around 30,000 persons were regularized.
Correct.
Subsequently, also, we continued with the process of regularization. But in the meantime, that Umadubi judgment came, Jitan Kolita judgment came. And accordingly, in a pending case before the division bench of our High Court, Lordship, we file a miss case, seeking leave of this honorable court to proceed with the regularization process. And therein, Lordship, court said, if it is not legally permissible, we cannot grant any permission. And the process stalled there. Thereafter, we never regularize any person. So far as master land works as.
Now, according to you, they are not even entitled to Upendas.
Upendas, they are getting that benefit, Lord. Upendas, they are getting. Upendas,
Upendas you are getting.
Upendas, they are
Getting, my lord. When this we are getting.
Including arrear.
Not
From
getting.
2017, they are getting.
From 17, my lord, we are getting.
After their regularization was cancelled, Lordship, they keep getting the masteral wages, Lordship.
My lord,
And
there
what
are-
happened to your review petition, according to you? Was the review allowed or dismissed?
Lordship, as it was tagged along with all those petitions, Lordship, simply it is mentioned as dispose of, Lordship. In that review petition, was stay order was also there, Lordship.
Then
Stay
how
of
is
the
the
earlier
court supposed to
judgment.
proceed?
So that
now?
is why, Lordship, coordinate bench, Lordship, may kindly see the last order, Lordship.
Last order of.
Of this case, Lord.
Yes, 24/10/2020.
Yes. Court said first review petition should be taken. There are.
So as per this order, the review petition has not been disposed of.
Not listed. Yes, Lordship, that is what it reflects, Lordship.
But how this order was passed if the review petition is shown
It
to
was
have
on agreement with both the
Already
parties.
it was disposed of, my lord.
In fact, it was on agreement, Lordship.
No, no. What I say, my lord, they could.
No, please see, the merit will come later,
Yes,
but
yes.
there seems to be a bit of a technical glitch in this matter. That has to be sorted out.
Yes.
In your anxiety to get something for yourself and oppose, let's not lose the
My lord.
tree for the bush. The point is, there is an order of the court where a direction has been issued. Then you have to challenge that order by filing a writ appeal. You can't do it like this.
Like, in fact, that order was reversed
That
by the
order
division
cannot
bench.
be passed.
No,
I
in
can-
fact, that order, Lordship, which my learned friend is showing, Lordship, that order has been reversed by the division bench, Lordship, in Upenda's, Lordship.
This order?
Yes,
No,
Lordship.
no, which order?
No, in that writ petition, Lordship, along with, there were so many writ petitions, along with which, Lordship, this review petition was also tagged. In those petitions, Lordship, that this notification of 2012 was under silence. In this petition.
Just 1 minute. So, learned single judge disposed of all the pending writ petitions where, let us say, unwittingly the review petition was also tagged
Yes,
and
Lord.
got disposed of.
Yes.
Those judgments were taken in appeal by the state.
Yes, Lord.
And in the division bench judgment, state versus Upendas, those were all set to rest.
Yes, Lord.
Correct.
Yes.
So the review petition was disposed of, means the single judge's order revives. The judgment and order of 1911-2007 revives.
Lordship.
Either the review petition, either the order has to be recalled and writ petition revived, or the review petition will be treated to have been dismissed. So the judgment of the single judge remains. Correct.
Lordship.
So as on date, the review has been disposed of without granting any relief to the state.
Yes, sir. That is my understanding.
Listen to this. When I'll ask you the question, then you answer. Yes, no, you will tell them. Now, a review petition which has been disposed of, maybe with a proper order, improper order, how can both of you agree that it will be heard again? How can it be done? This matter is out in the CIS.
Lordship.
Number two, if the review petition is disposed of, the judgment of the learned single judge revives.
Lordship.
Correct.
Yes, Lord.
That judgment, if you either you challenge it by filing an appeal, or that judgment has to be implemented. Otherwise, it will be a case of continuing contempt. Once these correct procedures are adopted, then the question will arise what order the court is to pass. Today, what order am I supposed to pass in this WPC? In this writ petition, he wants a direction on the basis of earlier order where the state had preferred a review. That review was rejected.
Lordship, even coming to this petition, Lordship, may kindly see the first prayer, Lordship. That is the notification of 2012.
That says it's not pressing.
No, second petition is second prayer is only the consequence of the first, Lordship. A decision was taken in 2012 not to regularize any further.
Effectively, what he's saying, implement the earlier order of
Yes, sir.
1911-2007.
No, for that, Lordship, may kindly say, if only implementation of the earlier order in that.
Mr. Saikya, you have to file a contempt petition. You take the correct steps, otherwise your client's interest cannot be helped. There is already an order of the court. Why should he pass another order? That's not permissible.
To implement that order, my lord.
Huh?
To implement that order, Lordship may dispose of this petition by directing the authority to implement that order, my lord.
No, why? That's not how it is done. You cannot start a new jurisprudence. The order I can pass today is dismissing your writ petition.
That order has.
Because your relief, what you wanted, has already been granted. You could not take the follow-up steps correctly. Your clients, either for wrong legal advice or whatever, we don't know. But that doesn't mean with the writ court will entertain another writ petition with the same because that cannot be done. Are you aware of Supreme Court decision which says it cannot be done? Same relief, two writ petitions cannot be filed. So you are asking for the same relief. And you say that you don't want to press a challenge to the first relief. So that means the rest of it is the same. If it is not the same, then you are in trouble. If it is same, then your petition is not maintainable. Mr. Saikya, you have to apply some mind as a lawyer sometimes. So what is the court supposed to do? And unless these things, there is clarity, it creates a lot of trouble for the system. I'm sorry, I cannot just mechanically go ahead in these matters.
I'll file a contempt petition.
File a contempt petition, then we'll ask them why they have not implemented the order. Today, the court cannot even ask him.
And secondly, Lordship, that very prayer, Lordship, challenging the notification of 2012 itself indicates that Lordship, he has accepted that his service has not been.
But he's giving up the prayer. He can give up the prayer.
The Lordship will consider that. Second prayer is only the consequence of the first one.
Whatever it is, that's
Lordship.
on merit. But why have you not implemented the order of 1911-2007, Mr. Nayak?
Lordship, my
Only because he has not
Lordship,
taken the right
Lordship,
steps.
once I filed the review petition, Lordship.
What has
court
happened?
Granted one
Dismissed?
stay order, Lordship.
Review petition is now dismissed.
It was not to our notice, in fact, Lordship. In fact, we have.
That can't be done. The court cannot say anything.
Lordship.
If they file the correct petition, then you will have to answer.
Yes.
Your review petition was rejected because only two orders can be passed in a review petition. Either allow it and recall the order or dismiss it.
Lordship.
In a review petition, the original order cannot be modified. I am telling you this, I have seen this happening. Learned counsels, please point it out. These are all absolutely nothing orders. Once an order is passed in a proceeding, a review is filed, the only order the court can pass is recall it and rehear the matter or dismiss it. I have seen in review petitions, the original order is modified. Some relief is granted here and there. Those orders will have no bearing, at least in this court. These are, according to me, not correct orders. These are not legally correct. So if the review petition, no order was passed of recall, then your review was dismissed. Then the original order of 1911-2007 revives. You have not preferred any appeal. Then if they file a contempt, you will have to answer why you have not implemented. Only that they have not filed it. Therefore, their question is not asked. The moment they file this petition, I'm not advising you to do it. You have to see your other issues.
My lord.
But on the same prayer, a second writ petition is not maintainable. That order I can pass today itself if you want. So now tell the court what you want, both all of you. You have agreed to revive a review petition which was disposed of.
Court granted.
And the
That
court
is why-
granted it.
That is why I was thinking of making submission that let the review petition get listed, Lord.
Sorry, once the review petition is
Dispose of.
disposed of, it cannot be revived like this. It has gone into the CIS as a dispose of matter. In the prayer of Senate Council for both the sides, these matters are adjourned for 2 weeks. First, to enable them to examine the legal issues arising in the matter, particularly with regard to the outcome of review petition number 57 of 2009 and the consequent bearing the same would have on the judgment and order dated 1911-2007 passed by the learned single judge in WPC
4759
4759 of 2007.
7.
Mr. Saikia, please examine these things. Otherwise,
Yes.
you will reach to the top and then come back to the bottom again. If you take a wrong course, whatever relief you get, everything will be set at naught. Someday when in the appropriate forum, the right issues are discussed, you will get a 0. So don't be in a hurry to jump the legal process. Your track, if it is not correct, that's the end of the matter. So please examine and see the judgments of Supreme Court division bench of this court where it has been held that you cannot file a second writ petition with the same relief. It cannot be entertained by the court. So today, if it is allowed, division bench upholds, Supreme Court will set it at naught. This is what is happening in this system. So please examine it.
That's one. আমিও examine করবো লাগিব।
Make please your lordship. Before agreeing the matter, I would like to point out one thing. An issue is there. Whether your lordship on that ground, whether it can be done or not.
In fact, in this case, I'm challenging the departmental inquiry punishment of the petitioner. And there is a, in the orders, appellate order as well as the order, they says that I have not asked for the witness who actually gave the complaint against me. He was not brought as a witness by the authority. So they say that I did not apply for his witness, as in the evidence here. In fact, I issued a letter. I've come to that. I've issued a letter asking that he should be brought as a witness, which was not accepted. But they say, while rejecting my appeal before the authorities, that I did not pray for that. That letter I have got, but that is not on record. But if I argue the matter, I can go into the matter. I can produce a copy of that. Or should I put that letter on record?
Would you rely on that letter?
Yes, because that is one point they have taken, specific ground taken in the affidavit.
Then it has to be on the record.
Then your lordship give me a week's time, I'll bring it on record.
Well, when the matter was taken up for final hearing, Mr. Y.S. Mannan, learned counsel appearing on behalf of the writ petitioner, submits that a copy of the letter dated.
Just no, a letter. Yes. Letter was issued at it was on, I think, 14/5/2007.
14/5/2007, issued by the.
It was issued by the petitioner to the respondent authority, the chairman of ASCB.
Lordship, before Lordship. Issued by the petitioner to the.
Chairman ASCB. At that time, your lordship, it was ASCB.
No, issued manner, addressed to the authorities by the writ petitioner would have a relevant bearing in the outcome of the writ petition, and therefore he be granted 10 days time to bring the said letter on record by filing a short additional affidavit with supportive pleadings. Full stop. Considering the ground on which the prayer is made and the fact that Mr. S.P. Sharma, learned counsel for the respondents, has no objection to the same, the prayer made by Mr. Manan stands allowed. The additional affidavit be filed within 10 days from today by serving advance copy upon the respondents' counsel. This matter be listed again after 3 weeks, along with the additional affidavit.
May I just, my lord, the order in which the impugn order here, that letter which my learned counsel has been, it's not been, there's no observation with regard to that letter. So there's no observation with regard
No,
to
there
that.
is an observation. I'll show that.
No, there's an
If you
order
want, I'll show.
at page
One thing
110.
I'm just trying to point out, this letter was actually, this is the 5th round of litigation by this. Earlier, four rounds were in favor of the petition. In the earlier case, this letter was annexed. Somehow it was not annexed in this letter. And they have stated, see the appellate order. In the appellate order, they have stated, I'll just point out, that the petitioner has not, your lordship, I'm not arguing on what he said. I'm
Achha,
just-
let him file it. He is the
Yes,
petitioner's
If
counsel.
it is not there, he cannot. I have seen it. That's why I'm taking the, your lordship.
Those are matter of consideration during
My
hearing.
lord.
He is the petitioner's counsel. Let him have his satisfaction.
Because that specific letter says that I want him as a witness, which I was not provided. That is one of the violation of natural justice. That is what I am trying to point. Much obliged.
I can tell.
Yes.
Lordship, in this case, Lordship, petitioner was a CRPF constable and he was dismissed from service, Lordship. On the ground that, Lordship, he has submitted a false SSLC certificate at the time of entry into service. And Lordship, proceeding was done under section 11(1) of the CRPF Act, that is for minor punishment, Lordship. And penalty was awarded with dismissal from service. And in this regard, Lordship, our High Court also judgment, considering that this 11(1) CRPF Act is a procedural irregularity to award dismissal from service, Lordship. And also orders for
Just 1 minute. Please take your seat.
Lordship.
Where is the, this is representation or appeal? 5 to 2000
Representation, appeal lordship is not filed.
5 to 2016.
Lords,
Where is that page number?
representation,
Mhm.
lordship at page 30, lordship. No, sorry, page 27 is the representation, and the representation will be forwarded to Special Director General by an order dated lordship in February 2016, page 30, lordship.
I'm sorry, Mr. Gupta, my lord, is in Lakes in court number 10, my lord. Another hearing matter.
Can't help, every matter can't be adjourned.
Page 27. Lord.
This was forwarded to,
Forward to lordship respondent number 3, Special Director General, Central Zone CRPF Kolkata. Page 30, lordship.
so this has not been disposed of till
Not
today.
been disposed of.
Then we'll ask him to consider this and dispose it of in a
No.
time-bound manner.
Lordship, considering
Will
one judgment of our High Court, lordship, where it has been set aside the impugned order. May I, Lord? Paragraph 57 and 59, lordship.
Yes, what is your stand? There is a, it seems, on similar grounds.
I am not in the case of Harish Gupta, my lord. Just now, my lord, I have seen and called, my lord. I have not yet gone through.
All right, you can't help it, then we'll, I can record your presence or record that none appears for CGC.
No, my lord, my presence.
You can't help it, every matter somebody is, that's your internal management. Where is the impugned order? No, I'll not adjourn it, I'm passing an order.
What is timing, my lord?
Let him come, or if he wants to, or.
Impugned, impugned at page 19, lordship.
Impugned order page
19. The translated copy, lordship.
Let's see the CRPF rules. Section CRPF
11.
Act and rules. Is this reported as good?
Lordship,
Is this any appeal preferred against this?
Lordship, probably a writ appeal has been preferred, Lordship, as informed by H. Gupta on last occasion.
Writ appeal has been preferred.
Preferred. Whether in this case or not, but some writ appeal is filed, they said.
Then you find out and tell us next week will be listed. Mr.
SK Singh or not.
Mr. S.K. Singh, counsel for the petitioner, submits that the petitioner was dismissed from service by order dated 14/5/2015 based on an inquiry proceeding initiated under section 11(1) of the CRPF Act 1949, read with rules 27 of CRPF rules 1955. However, 55 on the ground that at the time of entry into service as constable, (GD), the petitioner has relied upon fake certificate, contending that section 11(1) of the CRPF Act 1949 deals with minor penalty. Mr. Sinha submits that an order of dismissal from service could not have been issued by the authorities by relying upon the said provision, contending further that the said aspect of the matter has been dealt with by a coordinate bench in the case of Sri Chandan Rai versus Union of India and others, WPC number 4245/2012, whereby the order of dismissal issued to similarly situated constables of the CRPF had been set aside by this court. Mr. Sinha submits that the case of his client is covered by the said decision of this court. The learned counsel for both the sides would not, however,
Writ appeal on number, writ appeal number 95/2024.
then you write, Mr. Parasar, learned CGC appearing for the respondents,
Chandan Rai.
has submitted that the respondents have preferred a writ appeal
WA number.
against the decision rendered in the case of Sri Chandan Rai Supra, which is pending disposal before this court.
As per
In
order.
the form of writ appeal number
Writ appeal number 95/2024. As order dated 21/3/24, status quo to be maintained, my lord.
and there is an interim order dated
21/3/24.
21/3/2024, whereby status quo has been directed to be maintained in this case. Mr. Sinha prays for 10 days time to examine the said order and make further submission in this case. In view of the above and on the request of learned counsel for the petitioner, this matter is directed to be listed again after 10 days. You take this back.
Yes.
So if there is a status quo, then
Yes.
what can be done?
Yes.
See, I am not to comment here, but wrong quoting of a section does not take away if the procedure has been followed, if the principles of natural justice has been followed, really because a wrong section has been quoted. So therefore, it is doubtful whether this judgment will ultimately stand. You have to wait for it. And 8 years already gone.
Lord.
Reinstatement looks very difficult. Take back this.
Lord. Object.
May I please, your lordship?
My lord, in this matter, my lord, the petitioner, my lord, he retired from service on 31st July 2008, my lord. He joined service 2072, and during the course of 36 years of service, my lord, after 14 years, his first promotion was made on highly skilled grade 2. Then after 10 years, that is within 24 years, petitioners.
So he is already retired.
2008, my lord. Then petitioner, prior to his retirement, he made an application since after 24, during the 24 years, he got the 2 promotions, my lord. Thereafter 12 years he rendered service, but retirement, my lord, they counted the financial, instead of upgrading this financial amount, my lord, but he received that earlier,
No, but when did he retire, you said?
2008, my lord.
And then in 2018, he has come seeking
My
financial
lord, in this
benefit.
matter, what happened?
Where is the judgment? Pecuniary benefit beyond 3 years, not maintainable rate.
Judgment is not before us, but Malat, one thing is that PPO order, that is not not under silence. PPO order dated Malat 14 March 2012. That is not under silence in the Malat petition. These are already.
Maybe, but if there any financial claim, even if in a writ petition, cannot be made 3 years beyond the date on which it occurred. After 10 years of retirement, you can't come and say that revise my salary.
My lord, in this letter.
So we'll dismiss it in the new years, not now.
My lord, only one letter I'd like to draw your lordship and attention, my lord. It is from the department, my lord.
Mr. Decker,
Your
your
lordship,
client is not entitled to any relief. You better examine it and you come up with a judgment. There are 3 judgments of Supreme Court. Even assuming that you have a claim, after 10 years of retirement, he comes to the court saying that I should have been given higher pay scale on the request of a counsel for both the sides. Hearing of this matter stands adjourned for 4 weeks, at least again in the month of January 2024.
Oh, bless
You also examine this judgment.
Yes,
You
my
don't
lord.
have any
Yes,
case.
I will.
Achha, this is the last matter.
But this is a case where I've challenged the compulsory retirement of the delinquent officer who is supposed to actually otherwise retire in the year 2027.
Where is the order?
But the order is otherwise annexure 14, page 179. Before going to the order, may I take 1 minute of your lordship?
Yes.
My lord, as when I was serving as a BDO, there were certain works were supposed to be implemented under that my block, my lord. The persons who otherwise were involved were the junior engineers, etc. Everybody was there. I was supposed to monitor it, my lord. Some illegalities, irregularities, and in respect of taking away the bills and etc., the misappropriation occurred. An inquiry was conducted. And ultimately, my lord, in the inquiry, it seems towards me that insufficiency of service. And because of that, after the inquiry, my file was put up before the Honorable Chief Minister for transfer. But the Honorable Chief Minister with one stroke of pen said is not required. So on that ground, I have been given the compulsory retirement. And it is not the case of the other side. This is my case. They did not consider my entire service. It was on sole episode of that one incident. I've been given the compulsory retirement without taking my past service into consideration. And I will draw my lord's attention to.
First of all, show the impugned order, please.
My lord, page 179, annexure 14.
What is the date of the order?
My lord, 16 September 2023. And my compulsory retirement order was 26/9.
What is 16/9 then?
This is the order, my lord. And it was 16/9, passed an order after the,
Oh, 69 is the order and 29 is the order. What is the meaning of this?
my lord, 26.
Which is the main impugn order?
Main impugn order is, my lord, 26/9/2023.
But then why are you saying 69?
No, that is preceded by the order, my lord, of the review order of 16/9/2023.
Abedin, which is the impugn order here?
Both are impugned, but I will draw my lordship attention to page 182.
Yes.
That is the impugned order.
Yes.
My lord, this is preceded by annexure 14.
Yes, please.
179.
Let me see the FR, sir. One 56B. How old was the petitioner when when the impugn order was issued? What is his date of retirement otherwise?
My lord,
27.
31st January 2027.
Now, what was the age of the petitioner on the date on which the impugn order was passed? 16/9.
My lord, 56.
56. And you say that he had joined service in the year 1972, is it? Is that information available when the petitioner joined?
My lord, 2001. That is in the second paragraph. It's the petitioner took part in the selection process for the post of extension officer under Panchayat in the year 2001.
So it should be either 55 years or 25 years of service.
Yes, sir.
So
No,
55,
60.
No, see FR 55B, FR 56B.
I missed the book, my lord.
You don't have the book.
I actually, because of some sudden anxiety, I forgot to get my everything.
Oh,
Suddenly, something happened in the morning.
what do you want to do? Argue it today? You will not be able to argue without the book.
My lord, only one thing, urgency is there. That is the reason I did not go to the hospital. If you could accommodate for the day, my lord, I'll do it on Thursday or next Tuesday. Urgency is there, but because of certain thing,
Next Tuesday,
next Tuesday, yes,
all right. Mr. J. Abedin, learned counsel appearing for the petitioner submits that although he is prepared to argue the matter today, yet due to some sudden medical emergency, he would be required to go to the hospital. As such, the learned counsel is prayed for posting this matter again on 3rd December 2024 for hearing as a fixed item. Mr. Moore, learned additional AG Assam, appearing for the respondents, does not have any objection. The prayer is done. In view of the above, his writ petition is directed to be listed again on 3/12/2024 as a fixed item for hearing.
Obliged.
Have a look at 56,
Yes.
FR 56B.
Be obliged, my lord.
Any other matter?